shares working for you?
Oh, sure, yeah.
Great.
Let's see.
Thank you for that, Cersei. I
No
think we
worries.
shares working for you.
Oh, sure, yeah.
Great.
Let's see. Are you able to see that okay?
Yes, okay.
Okay.
I'll be showing some slides first, but just wanted to make sure that you're all set.
Perfect.
Okay,
We are live,
okay, thank you so much.
and I am going to hop to this other piece. But William, I'm very excited to watch this later, and it's been a pleasure working with you, and congratulations on all of your successes.
Oh, thank you so much, Cersei.
Look at that beautiful certificate in the background.
Yes.
Oh yeah, oh my God.
I'm glad it's showing through. Usually the resolution's
great.
not super great on the webcam.
All right. Well,
Right.
you take care and all the best. We'll be in touch.
Sounds good. Thank you.
Right.
Check.
Yeah, you're like, make
Your host, everything's good?
Yes, I think so.
Okay. And the last thing I'm going to do is I will make you live.
If you want to, sure. Yeah, we can.
Are you good to go to do it, or I can?
Yeah, I'm happy to.
Okay. Well, I can make it live. I just want to
I did. I made it live already.
make it live. All right.
Okay. All right. See you later.
Thank you. Bye, William.
All right. So I will pull my slides up first. Okay. Trying to go ahead and share my slides here. All right. Are you able to see those, William?
Yes.
Okay, great. All right, everyone, welcome to the Boston Congress of Public Health webinar of the week. We're excited to have you with us. Today, we have William Lee, who's going to be addressing public health threats through mass tort litigations. But first, we introduce William. I want to introduce myself. I'm co-CEO and co-Chief Strategy Officer of the Boston Congress of Public Health. Very happy to bring this with you. Our guest speaker today is William Lee. He is one of the health innovators to watch winners for the cohort of 2024 for the Boston Congress of Public Health. But before we jump into the webinar today, I wanted to just mention that the Boston Congress of Public Health is happy to celebrate its third year anniversary of 2024. We inaugurated in 2021. And we have a number of different things that we wanted to present to people. So during these special webinars, going over some of the new membership benefits that we have. But just by attending this webinar, or any of our future webinars coming up, you are able to get an elite membership with the Boston Congress of Public Health, $175 for 3 years. And there's a number of different things that we've now rolled out to be able to get that elite membership with us, including greater access to more awards and recognition, not just the Health Innovators to Watch that William won, but also the 40 under 40, Outstanding Practice, and Distinguished Career in Public Health. A number of different grants that we're giving out, ranging from $750 to $1,500 for different grants that you want to do for different research or academic progress, publications, a number of different showcases for membership, consulting, mentorship opportunities, as well as being included in our speakers directory. If you have any additional questions, feel free to email us at communications@bcph.org. But we have a number of ways to continue to follow us, not only through this webinar, but through the BCPH studio on YouTube, as well as other ways to connect on LinkedIn. So as a member, bcph.org/elite. If you're on this webinar today, $175 to be able to get that 3-year membership benefits. All right. So William, I will go ahead and introduce you, but obviously cannot steal your thunder too much. So William Lee is leading the Kershaw Burlow Scientific Practice Group. He supports its nationally recognized mass tort and class action practices. William works at that intersection of epidemiology, law, and policy, and collaborates with leading experts to develop scientific and medical evidence and perform epidemiological and biostatistical analyses as an expert himself in support of federal and state trial, appellate, and Supreme Court litigations. William earned his doctorate of law with honors, Phi Delta Phi from Emory University, his master's in science and chronic disease epidemiology from Yale University, and his bachelor of science in cell and molecular biology from Duke University. William has worked at a number of high-profile universities and federal scientific agencies, including Vanderbilt, Dartmouth College, and the National Center for Health Safety and the Centers for Disease Control and Prevention. Let's all go ahead and welcome William for the webinar of today. Thank you so much, William, and take it away.
Yeah, thank you so much, Dr. Carpenter, for the opportunity to speak with this group on a topic that's near and dear to my heart. It's what I've devoted the better part of the past 5, almost 6 years since graduating from law school, and it's sort of a marriage of my prior career in public health as an epidemiologist with my more recently found career path in the legal profession. And so I'm going to go ahead and share my slides. Let's see. Can you see that okay, Dr. Carpenter? Perfect. And yeah, I just want to want to state that these slides are really just meant as guideposts for us to spur discussion. We have an intimate group here. If anyone has any questions or wants to steer the discussion in a specific direction that you're interested in, please feel free to drop a line in the Q&A box or the chat. We can talk about what folks are interested in. Otherwise, I'm just going to kind of stick with some of the prepared materials I have until that point. Let me just make sure that I can see the chat box as stuff is coming in. Okay, perfect. Okay, yeah. So let's see. So yeah, I won't restate some of the things that Dr. Carpenter mentioned about my background. I will say that just one addition. For the past couple of years, I've served in the American College of Epidemiology as an elected member in both their ethics and policy committee, doing work at that intersection, as well as I'm a director on their board for the foundation that supports the work of the college, both policy, research, and education. And so that's, ACE has become my academic home, so to speak. It's where I found fellowship, been given opportunities to collaborate with like-minded epidemiologists, and it's where I keep pulse on the latest developments in the field. Let's see. And just some initial disclosures. So I do serve in scientific leadership in some of the litigations we're going to be discussing. And so, for those reasons and others, the views that I express today are my own and not necessarily those of Kershaw, Talley, Barlow, my firm, or the American College of Epidemiology. And I do want to take a moment to thank Dr. Carpenter, her colleague, Dr. LeCompte, and Saher, who's who reached out about this opportunity, got everything organized logistically, and just have been amazing, colleagues and friends throughout this process, and as well as a few folks here at KTB, Bill Kershaw, who's my managing partner, for support, Ian Barlow, another senior partner, and also Vin Lee, who is a member of a colleague of mine that I work closely with on our science practice here. And so, yeah, as I said right up front, please interrupt with questions. This is not supposed to this is not necessarily a didactic experience. Our time here today. And one of the things that I want to start off with is really a challenge for you, right? I want to start off by setting the table to get us to think about litigation as part of the research and development process that you might be more familiar with as public health practitioners, as epidemiologists, as scientists generally. Because, as someone who works at that intersection between law and epidemiology, that's how I think about litigation with my science hat on. And, I challenge you to keep an open mind as we dive deeper into this discussion, and we'll use specific examples, especially at the end, to kind of give you some tangibles in terms of how how litigation can be married, and at least in my mind, to the R&D process. Before we get to the examples, I do think it's worth spending some time laying some foundation. This might be the first time that folks have heard about mass tort litigation, so we'll spend a bit of time covering that topic, as well as specific aspects that I think are really important for folks to understand as we guide the discussion more towards its intersection with epidemiology. And that includes discussion of some of the key facets of that we have to prove in litigation, including causation, liability, and a subset of liability, which is notice. Of course, experts play a huge role in this process. Experts such as the folks on this call, in terms of proffering admissible evidence for the court and for the jury to consider as finder of fact. We'll talk a little bit. I don't want to oversteer the conversation towards challenges that we face. This is an area that I've been developing on the policy front along with my team, in terms of just getting the judiciary to update its thought processes and frankly the jurisprudence on which has fallen behind the times in terms of how modern public health practitioners think about some of these issues. But we'll just touch on that a little bit, and then as I mentioned, we'll talk. We'll go through some specific examples to give folks a better handle on this intersection. And so I want to start off by by going over something I think that most folks, if not everyone on this call, has a good handle on, which is the different phases of research and development, and how and really there are checks and balances. It's a system of checks and balances that's built into place in the regulatory framework of this country, for purposes of safety and efficacy, or at least non-inferiority in the past couple of decades in terms of new interventions. But of course, we start off with preclinical non-human type studies, research, using both in vitro, in vivo, and animal models. If that proves fulsome, the next step is to initiate human clinical studies. And as folks know, there are multiple phases of that. Phase 1, phase 2, phase 3, always testing for safety, but increasingly for efficacy, especially as you move into phase 3 and sometimes if a phase 2b is conducted. But I want to point out a problem that might be obvious, but it's something that's taken me a while to really kind of distill down and articulate, which is that rare and or latent adverse events are not necessarily detectable, right? They're not theoretically detectable in experimental studies. And an example of that would be if we encountered an adverse event with rarity of, that happens only once every, in every 1,000 patients, or that's more latent than 1 year, that's not typically going to get picked up in even in phase 3 studies, because we just don't have enough volume, right, and enough follow-up period. I see there's something in the chat. I just want to, okay, never mind. And so to me, the clinical, the experimental period is really important, but it's not the whole answer to the solution in terms of identifying safety or efficacy issues. And really, it's the post-market period, that messy period where we have, real world data coming in to inform clinical and epidemiological decision making, that I think is sometimes underutilized and really important in steering the safety and efficacy discussion. And here, what we'll have, organized phase 4 studies in some cases, depending on the sponsor. A large source of data comes from the pharmacovigilance space, where adverse events are reported necessarily, or not necessarily, but depending on the severity and other circumstances. Sometimes they're mandatorily reported, sometimes they're voluntarily reported to the FDA and to the sponsor, to the manufacturer. And then, of course, we have my bread and butter, which is the epidemiological observational studies that can arise when we follow cohorts and or do other types of study design on data that starts populating the post-market period. And so the way I think about litigation's role in this process is that it comes at the very tail end. So it's where safety issues and to a lesser extent, sometimes efficacy issues that were ignored or undetected, or for whatever reason, just, not dealt with at any earlier period of time in this process. That's where litigation has stepped in my experience, to sort of right the ship at the very end in a direction towards fairness and justice, when all of the other checks and balances in this process, have failed. And so that's where litigation fits in. And I'm sorry, I'm having a little bit of lag on my end. Trying to get to the next slide. There we go. And it's a specific type of litigation that I have in mind. It's what, my firm and my team, the space that my firm and my team work in. It's called mass tort litigation. So it might not be something that you've heard of before. So I want to take just a couple of minutes to set the table and give you an introduction. And so the first most important thing is that we're working in the space of civil litigation, not criminal litigation. And so what is civil litigation? It's essentially everything that's non-criminal. And there are multiple subject areas within civil, some of which I think even to a non-lawyer, it should be fairly obvious, or something that you've encountered before in your ordinary lives. If you've bought a house or rented an apartment or purchased a car, you've likely dealt with contracts, or real property, for example. But there's a subject within civil litigation called torts. And those are really just, acts or omissions that can give rise to harm to another person for which the courts impose liability and relief. So an example of that would be, a personal injury claim, for example. There are also economic torts where, if money is at issue and not necessarily an injury. But the other thing, for the folks on the call who are not necessarily familiar with the U.S. system, U.S. legal system, it's a system based on common law, not civil law. So what that means is that there are statutes that are put in that are promulgated by some sort of legislative body at the federal or state level. But then the statutes are pretty sparse sometimes in their language, and it's really the judge-made law, the case law, that adds contextual richness and interpretation to the statutes that were initially promulgated. And what we have here is an adversarial process. So the courts can't just adjudicate an issue sua sponte. Each party, a party has to bring a lawsuit before the court that's ripe for adjudication. Each party presents its case. Each party will develop the facts in support of their case. They'll retain and develop experts for trial. And another uniquely American aspect of our jurisprudence is that we have trial by jury, right? It's not the judge who ultimately decides, it's the jury. It's a jury of one's peers who serves as the finder of fact in trial court. So they'll hear all the evidence that's presented by both sides and render a decision guided by the court sort of refereeing and articulation of what the legal standards are and the jury instructions are. And so that's kind of a 2 minute reduction of the American jurisprudential system. But complex litigation is a subset of civil litigation. It's there are two main buckets in complex litigation. One of which is class action litigation, and the other is mass tort litigation. And so folks might be a little bit more familiar, have heard of class actions before. This mass torts is the cousin or the brother or sister of class actions. So the way I think about it, which is an imperfect definition, but it's something that I think can help guide our conversation as scientists, is class actions are characterized by a common exposure and a common outcome. So everyone was exposed to the same thing. Everyone experienced the same outcome. Whereas in mass tort litigation, it was the same exposure, but differential outcomes. For example, pharmaceutical and medical device mass torts, which is what I focus on. Folks took the same problematic drug, perhaps, or received the same problematic intervention, but their outcome, their harm was differential. Some people might have died from it. Others might have been severely injured, others less so. And so because we have that differential outcome spectrum, that gets dumped in the mass tort bucket, also called a multi-district litigation in federal court, or an MDL in federal court, as opposed to class action. And how does this process work? Because these are litigations that are not just one party or one person suing another party or another person or entity. They can involve thousands, tens of thousands, in some cases, hundreds of thousands of patients per litigation. And so how these typically develop is that there are initially individual cases filed all around the country, alleging kind of a common nucleus of facts and exposures and outcomes. And when that starts happening, there's typically on the plaintiff side, firms that are representing the plaintiffs or the patients, which my firm does ordinarily. There's a coordination motion that's filed, essentially asking a senior judicial panel called the Judicial Panel on Multi-District Litigation, the JPML, to coordinate or consolidate all of these cases together into one big litigation, because they're all related. And that plays into two important aspects of American jurisprudential theory. It's judicial comity and efficiency. So we don't, want there to be hundreds of thousands of individual cases around the country. That would take a lifetime or two, to try and to adjudicate. So there's efficiency in coordinating these cases together into one bigger litigation. There's also the aspect of judicial comity. So we don't like different judges and different jurisdictions reaching different decisions on the same facts and the same law. And so for reasons of comity, we like there to be consistency among these decisions that are reached. And so that process of coordination allows the courts to reach that. And so the JPML will review kind of the facts and the laws and claims that are alleged. If they merit further litigation, and sometimes they don't. I would say about 50% of potential mass torts drop off after JPML review. But if they do, if there is something there substantively, then an MDL, a multi-district litigation, is formed. And then there's a whole process by which these litigations get worked up. Leadership is appointed, of which my firm and I are part of that in a number of litigations. We begin the process of discovery, which is obtaining documentary evidence, deposition evidence, testimony, both from fact witnesses within the company and other late witnesses, as well as with experts. There's a process by which specific patients or plaintiffs are selected to go to trial, that are aspirationally or theoretically they're representative of the entire national population of plaintiffs. And so that's the bellwether trial selection process. And ultimately, if the litigation pushes through until the end, we'll have trials that will then inform a global settlement or verdict. And so that's typically how these MDLs or multi-district litigations or mass torts, many words for the same concept are adjudicated logistically. And so I think I'm going to skip this slide. I think we can make these slides available, right, Dr. Carpenter? Perhaps. Okay. But it's essentially an infographic that one of the firms that we work with often put together, which I thought really kind of distilled down kind of the differences and similarities. But I think for our purposes, what we covered was sufficient. And so I want to move on to just a few kind of heavy hitting topics that just to set the framework for how how public health might intersect with litigation. And these are things that we have to prove or disprove in a litigation, depending on which side of the aisle you're on. And so one of the big things that often confuses, or it confuses me if I have my science hat on, is that there are actually two types of causation that we need to prove in law, and one of them there doesn't have a sexy name. It's just general causation and specific causation. So general causation is when plaintiffs bear the burden of proving that a particular exposure can generally cause or contribute to a particular outcome. And then they also have, at trial, the burden of proving that a particular exposure actually caused or contributed to a particular outcome in that person at trial, right? So it's, the way that I think about it is that general causation is that it can generally happen at a theoretical level, and then specific causation is that, yes, it happened in you specifically in this plaintiff, in this patient. And there are different tools that one can use to prove general causation and specific causation. So specific causation, I think, in all jurisdictions that I know of, differential diagnosis by a medical doctor or provider is sort of the gold standard way of showing that. Interestingly, in some jurisdictions, epidemiology can also be used if you can show a consistent elevation in risk above 2.0 across multiple cohorts or studies. That can also be probative of specific causation, for example, in California and in the Ninth Circuit, which is a federal circuit that covers the state of California. General causation, on the other hand, there are other lines of evidence, for example, epidemiology and mechanism, toxicology, pharmacology, for example, which we'll cover in a bit, that can be used to show that. But I did want to point out that, it's not just the fact that a drug that there's a safety or efficacy problem with a drug. That's not enough by itself, for litigation to ensue. There has to be something more than that. There has to be some sort of liability or culpability on the part of the defendant, right? Maybe they maybe there was some underreporting of adverse events. Maybe there was withholding of information from the label, or no warning or insufficient warnings. There are many aspects or many theories of liability that are potentially operative, but there has to be something more than just the fact that a drug causes adverse events. That alone is insufficient for litigation. And so typically with liability also comes a subset of that, which is notice, which is, when did a defendant know there was a problem, or when should they have known there was a problem, given a number of different data points, one of which is just information that's publicly available. For example, within the FDA adverse event reporting system, adverse events that are reported to the FDA and to the manufacturer. That's often a source of information for us to identify potential safety signals that warrant further investigation. There are also, of course, published epidemiological studies and other types of studies in the literature that indicate a potential problem might exist. There's also stuff that's not publicly available, such as documents that are obtained or documents and communications that are obtained in discovery from the manufacturer themselves. And not to overcomplicate things, but there's also a very different sort of evidentiary standard that we as epidemiologists operate in, or a scientist operate in, versus what the legal system operates in. And this is often a point that, when I'm working with experts in the legal space, we have to, really kind of work through this issue, because there is a big difference here, which is, in at least when we're publishing in the peer reviewed space, we typically have a certain critical value that we want to reach, 95% perhaps in a lot of journals, 90% in some of the environmental literature journals that I've seen. But in the law, it's significantly attenuated. So in civil litigation, the evidentiary standard is, you just need to be certain, greater than 50% certainty, more likely than not. That's the typical standard in civil litigation. In some situations, for example, I can think of a couple. There's the vaccine litigation out of the Federal Circuit, the Camp Lejeune litigation in the Fourth Circuit in North Carolina. The evidentiary standard there is even lower. It's equipoise. It's, we just need to show 50% certainty, as likely as not. And so, that really is a divergence from the way we think about, uh, statistical significance as scientists. And I know I'm really kind of keeping at a superficial level here. There's a lot of discussion on whether statistical significance, or having hard and fast cutoffs for critical values is even right, and or even the right way to think about things. But just to distill the conversation down, there's that kind of superficial big difference. And then with respect to specific causation, the legal standards are all over the place depending on which jurisdiction you're in. In California, for example, the language in the jury instructions is that the jury just needs to find that the exposure contributed in more than a remote or trivial fashion. In New York, it's a few percent, whatever that means, and in some jurisdictions, you do have to show, or the case law implies that you have to reach independent causation. So, sufficient but not necessary causation. So I think this really, the standards for specific causation really emphasize a problem we have with the American jurisprudential system, which is that it's decentralized. There's, it's jurisdiction by jurisdiction, both at the federal level and at the state level, and within each state. And so, because it's decentralized, one has to really kind of understand and tailor their scientific work towards the jurisdiction in which the litigation is operative. So we have a question in the.
Yeah, you saw that, yeah, in the chat.
Yeah. So someone asked, how would this legal experiment look in the legal and court systems of other nations? That's a really good question. I know that some of these litigations, because we're dealing with multinational defendants, and obviously folks don't just take these interventions, or use these drugs and devices here. I know that there's parallel litigations in other countries. For example, one of the litigations that I'm involved in, that my firm is involved in, concerning Tylenol, there's a Canadian version of this. I know sometimes we have international patients from other countries ask to join these litigations. I'm not 100% sure. I think that's a really, it's because it's pretty decentralized. Maynard, it's hard to kind of give a universal answer to that. I think the way that I understand litigation, or this type of litigation, it's best effectuated in a system where you have an adversarial process, right? So like in countries where it's a civil law process where the judge is sort of the arbiter. I'm not sure kind of how that would play out. I'm more familiar with the civil process where the parties are working up evidence in support of their side and then presenting that to a fact finder at the end. But certainly that does exist in other civil countries. There are these parallel litigations going on in different countries that concern the same the same facts. And so, yeah, so as Maynard kind of previewed, here the court has a role, but the jury also has a role, and that's an aspect of civil litigation in the United States and in other countries that are civil law countries, where the court really serves as a referee, right? They're making decisions in terms of what evidence is relevant and admissible insofar as it's reliable, it's valid, it'll help the jury in its capacity as the finder of fact. So it's really the jury that makes the ultimate call in terms of liability, in terms of whether causation has been satisfied, and in terms of damages, right? What extent of damages is reasonable. The judge can step in at some points after the jury's rendered its decision. But we're gonna kind of distill it down and keep it at kind of the most common the most common way that this procedure runs its course. And so I mentioned there are different lines of evidence that are used to prove or to demonstrate general causation. And epidemiology is one of the most important lines of evidence. It's, I often call it or joke about it that it's the king or the queen of the different lines of evidence, because most jurisdictions rely on that as its primary line of general causation evidence. Mechanistic studies in animal models or otherwise, the circuits are split. Some jurisdictions will allow it to sub in for epidemiology when there's a lack of that human data. Some jurisdictions will only allow it as a supplemental or adjuvant line of evidence, and it can't necessarily supplant epidemiology. And so the jurisdictions are kind of mixed on preclinical data and its relevance to general causation. We'll also have especially in drug and device cases, regulatory experts come in to discuss the process that we had started with in terms of any clinical data that's available, and also stuff during post-market in terms of pharmacovigilance data. We'll have pharmacology and or toxicology experts come in, depending on whether we're having issues, safety, efficacy, or otherwise, at a therapeutic or supra-therapeutic dose, respectively. We'll also bring in case-specific experts, such as medical doctors, for example, for purposes of demonstrating specific causation. And those are all aspects of what the court calls expert discovery, which is when you bring in experts to work up, to develop, and ultimately to proffer evidence for the jury to consider. There's also a separate bucket that's related, but it's called fact discovery, where those are not necessarily extrinsic experts, but those are folks who might have other types of evidence that to proffer for the jury to consider that's relevant. For example, there's documentary evidence, it could be emails, communications internally within the company. You could have corporate fact witnesses that have knowledge of certain aspects of the defendant and the defendant's functioning. You also have folks called PMKs, persons most knowledgeable. It could also be called persons most qualified, PMQs, and in some jurisdictions like California. But those are essentially just folks who the company has designated as their person most knowledgeable on a specific topic. So, and if one were to subpoena and depose, a company on issues regarding epidemiology, typically the company will proffer their PMK on epidemiology, for example, their director of epidemiology, to give testimony on how on how the company's epi division is run. Okay, and then let's see. So I'll just touch on this really briefly. I think for folks who've done expert work on the call, this should not come as a surprise. But I think for folks who are, whose practice is more academic in nature, this is a little bit different from the framework that you work in conceptually. And so the way I explain it to experts who are doing this for the first time, either on a consulting or testifying basis, is that expert work is really an exercise in advocacy, but it's bounded by the limits of reasonable methodology. So you can't really just give any opinion out there, in the left field, right field. It's, if it's not grounded in reasonable methodology supported by reasonable, valid and reliable facts and data, that opinion is going to get excluded by the courts, right? As by the judge as in its gatekeeping function to exclude bad science from reaching the jury. So this little graphic I have here is that so P stands for the patient or the plaintiff's expert. D stands for the defendant's expert, and so as academics we often publish in kind of our safe space, which is right in the middle where the C and J are, right? The C stands for court, J stands for jury. So we often don't want to steer too far towards the edges because it's just not academic to do so. But in litigation, P and D, plaintiffs and defendants experts, often have to start at the boundaries, at the bounds of reasonable methodology. You don't want to deviate too far outside of that, or denoted by the P star, P asterisk, because then you'll get excluded. But it's an exercise in advocacy, and you have to use methodologies that are reasonable, that are supportable. But you're doing this from the perspective of of an advocate from the side that you represent or that you're trying to help. And the other side is going to do the same from the other side of the spectrum of reasonable methodology, hopefully. And the truth ends up somewhere in the middle. The court and the jury, as finder of fact, they will take into account all of the evidence that's presented by both the plaintiff's experts and the defendant's experts, and arrive at a conclusion that's somewhat in the middle. And so that's a deviation, I think, from the way one and we would think as academics in terms of what's the ultimate or what's the desirable outcome. And we there's an indirect sort of leaving it to a third party, to the jury, to the fact finder, to reach that ultimate conclusion, whereas in academia we would typically just publish already in that midline. And so kind of wrapping up the legal section, or the legal foundation section of our time here, there are the damages and other relief. This is the reason why litigations ensue, right? So there are different types of damages at the end of when a litigation settles or reaches jury verdict. One of which is economic damages. Those are costs of healthcare, for example, medical costs, past, future, and present, that goes to that the jury can award to compensate the patient for issues associated with with a problematic intervention. There are also non-economic damages. Those are, I think, what are typically thought of as like pain and suffering damages. So, damages associated with the emotional toil of having to go through that process. There are sometimes punitive damages, and those are damages that are issued by the jury to punish and to deter defendants who've done something egregious. And we'll go through. I'll give a specific example of that we can talk about in a little bit. And then there's also especially in the class action side of things, remedies regarding providing injunctive relief for a defendant to stop doing what it's doing, and oftentimes there's kind of an intersection of what we're doing on the litigation side with what regulatory agencies are doing. And so we'll also go through a specific example where the litigation really ensued or instigated regulatory action on the part of the FDA.
Dr. Lee, can I quickly say that we do have a hand raised, Maynard. So let's see here, Maynard. You are unmuted.
Sorry, that was a mistake. I hit that button by mistake.
No problem.
Great. Yeah, I see your comment, Maynard. Just kind of glancing over it very quickly. I'd love to connect with you offline after this, Maynard, to kind of pick your brain on this. It's some of the stuff that you've mentioned here. It's stuff that I thought about a lot, kind of, not necessarily on the application side, but in terms of the theory side of things and the policy side of things. Yeah, so my next slide here is what I mentioned earlier. I don't want to spend an inordinate amount of time on this, but I do want to make a plug because this was a study, or not a study, I'm sorry, some commentary that I had published with the Boston Congress of Public Health in their journal earlier this year. But it really is, it gets to kind of the policy side of the work that my team and I have been doing, which is the fact that the court systems, keeping in mind that they're pretty decentralized and different courts, different jurisdictions have done their own thing. But the courts have alarmingly and increasingly applied one aspect of the admissibility standard for expert testimony as essentially a hard and fast requirement. And multiple circuits, multiple jurisdictions have essentially said that unless something is in the peer-reviewed literature, it's inadmissible, black and white. And so I think, if one kind of thinks about what types of litigations, what types of public health issues could arise in litigation, one realizes that sometimes it's emergent issues, things that have not fully been flushed out yet in the literature, that are often the subject of litigation. Maybe there's significant adverse event data being reported to the FDA, and that's open an investigation on their own end, which has then, prompted lawyers and scientists to, start writing about it, to start researching it, to start investigating potential liability. It could be recalls or other regulatory actions, whether voluntary or not. But they're really things kind of at the forefront, at the incipient stages of a public health threat, not necessarily stuff that's super well fleshed out and developed, where we have a robust body of literature that already exists. And so there's a little bit of a disconnect between the way the judiciary has treated the peer-reviewed literature versus the types of litigation and the types of public health issues that are being brought before to its attention. And stepping back a little bit, maybe less black and white, but more in the gray zone, some jurisdictions have not outright excluded unpublished data, but they've circumscribed expert testimony insofar as it can't exceed the express limitations identified in the literature. So, whenever we read a study or we're writing a study ourselves, we always have a, limitation section to talk about potential biases or design issues or what have you that that are just intrinsic to our study design or to our sample that we just want the reader, our colleagues, to be aware of. But courts have sort of perverted that into a hard requirement that if it's a limitation that's been identified, then it can't, that limitation is essentially concrete. It's not subject to rebuttal. And so that brings up, kind of that plays into what I just mentioned, which is that, it really precludes litigation for emergent safety issues where these issues have not been fully fleshed out. And it's magnified by the fact that there's a discordance between the way that lawyers write and the way that scientists write. So the courts interpreting scientific literature, they're looking for causation language. And as we know, we as scientists, we are conservative writers. We don't, we don't use the type of language often that the courts are looking for 100% of the time. And so there's some pretty good data in the study, I'm sorry, in the commentary that I have listed on the bottom that we published in HPHR, which is now the Boston Congress of Public Health review, but talking about that issue and really, kind of shedding light on the fact that this discrepancy or this discordance exists. And, I kind of make a call to action or raise a call to action, which we're developing on the policy front in ACE and other entities where it's really not, the aspect that should be considered is not so much the fact that it's published or peer reviewed. More so, the focus should be on whether the expert is qualified in that space and whether the data that they're proffering is reliable and valid. Because what's happening at a practical level is that you have the dean of Harvard School of Public Health getting excluded on a causal analysis that that he knows how to do and that he does routinely in his published work. You have the chair of the chair of pharmacology at the University of Southern California getting excluded for giving an opinion on a certain aspect of pharmacological data in the studies because of these hard and fast rules. You have preeminent experts in their field getting excluded for reasons that in my mind are improper. And so that I'm just kind of laying that foundation for folks if you're interested in exploring that further. But we'll kind of end this aspect of the conversation here. And so so with the last let me just make sure there. Oh yeah, thank you, Maynard. Got your email. And so just want to go over a few examples to give some concreteness to what we've been discussing. And we'll start here with litigations that have already settled, because these are cases, these are litigations involving hundreds of thousands of patients where, the courts, the juries, scientists, experts, even regulatory authorities have confirmed that these interventions were problematic. And it was really the litigation aspect of it that spurred that further investigation and ultimate resolution. And so the first is a medical device called Esure. It is a permanent sterilization contraceptive device that was sort of controversial from its inception. It was initially marketed or received market approval, I think back in 2008. It was a startup company. It was ultimately acquired by a much larger company. But the liability aspect of this comes from the fact that the startup that had initially gotten market approval failed to report a number of adverse events, numbering in the thousands, to the FDA, where they were otherwise required to under the CFR, under the Code of Federal Regulations. And so they were underreporting pretty serious adverse events by the thousands. This device was sort of problematic from the beginning because there were reports of fracture, breakage, perforation of the female reproductive tract, migration even to other parts of the body, resulting in perforation and other serious adverse events. But it's a device that essentially is implanted by the physician in the fallopian tube, and it causes some scar tissue to develop around the coil, therefore occluding the lumen of the tube, and therefore conferring sterility. But because of all those problems, what happened was that when Esure was acquired by Bayer Pharmaceuticals, a much larger corporation, there was an immediate rush of adverse event reporting. It was, it went from essentially very minimal to no reporting all the way to hundreds per month were being reported. And so that caught the attention of the FDA. Over time, this device the regulatory actions coincided and in some instances were spurred by the litigation. As the litigation developed, the FDA, was performing its own investigation as well. And, Bayer was sanctioned multiple times for itself failing to report adverse events, in a timely and consistent fashion. This device had a number of sort of extraordinary measures as far as devices go in terms of regulatory actions. There was a black box warning slapped on the label, which is pretty common, I think, for pharmaceuticals, but much less so for devices. There was a physician-patient checklist, an informed consent checklist, multiple sort of stopgaps along the way or checks and balances along the way to make sure patients were being informed of the risks of this device as the literature, as the safety data around it was growing. And ultimately, this device was pulled off the market in 2018, right around the time the case was settling in litigation. And the FDA even went so far as to do a post-market review. I'm sorry, a post recall review of the safety data in fairs. And yeah, I'm sure you can just pull it up on with a Google search. But yeah, you can see that even the FDA found that there was significant issues associated with this device that were not associated with with other forms of permanent sterilization. And so I think that's a really good example of litigation really intersecting with policy to where otherwise there would have there might have been a delay or a gap in terms of like the regulatory workup. The litigation really stepped in to accelerate that aspect of regulatory enforcement. Another example of this sorry, I'm just taking a look at the chat box. Another example of a past litigation where I think the litigation really did change the framework or the tide of how things were done were the hip prosthetic litigation. So there was a number of individual litigations against different defendants, including Johnson and Johnson's DePuy subsidiary, Stryker, and Smith and Nephew. But for a long time, prosthetic hips were essentially metal on metal. So in terms of like the ball and socket joint, the acetabular joint, it was a metal ball on a metal socket. And there was growing literature on essentially metallosis happening, where metal ions were being shed off the due to friction and due to just wear and tear of that artificial joint. And you can see the literature developing kind of in real time in terms of the localized, the adverse local tissue reactions. But there was also some literature developing on in terms of systemic adverse events where those metal ions would migrate to other parts of the body. And the literature is a little bit mixed, admittedly, but I think there's some literature, for example, on type 4 hypersensitivity reactions being elicited due to systemic exposure to these metal ions. And so I think that's a good example. And this litigation involved maybe 20,000 patients or so across all the different defendants, but it's an example of a problem being called out during post-market that wasn't previously identified in the experimental phase or in earlier phases of the research and development process. And the litigation, as the litigation progressed, so did research on this issue, and so did the body of published literature on this issue. And ultimately, if we move forward to today, metal on metal hips are no longer they're disfavored now in favor of metal on polyethylene joints, which are more common. So I think that's another pretty good example of litigation being a checkpoint towards the end of the R&D process for an issue that wasn't previously discovered. And so here are some ongoing litigations that my firm, my team are involved in. We won't go over all of them, I think, for the sake of time. But I'll point out just a couple. I think the ones in red were the ones I wanted to just touch on a little bit. I think the Tylenol litigation is a really good example of something that's developing, or and in some respects, to some scientists, has already developed. And it's so there's a pretty robust body of observational data of epidemiological studies that show an association between prenatal or in utero acetaminophen exposure and the development of autism and ADHD, essentially neurodevelopmental issues, in after that in utero exposure. And when I say there's a pretty robust body, it's there are over 24 cohort studies that are showing a remarkably consistent elevation in risk of somewhere between 1.5 and 2.5. And this is across cohorts in 6 different continents. So it's a, in terms of like triangulating that cohort data, which is something that my team and I have thought a lot about. That's pretty remarkable to me that we have so much data already on this. But I think, this litigation is currently on appeal for a number of reasons regarding the science. So reasonable scientists can and do disagree, right? And that's fine. That's what, we're not proposing that the science is fixed and litigation is just a way to essentially present one side's evidence to to the jury. Reasonable scientists disagree in academia. They can also disagree in litigation. That's why we have experts on both sides of the aisle advocating for their respective positions. But one of the things I do want to point out is that this because of the litigation, there has been some movement in terms of academic societies and in terms of the FDA itself reviewing this body of evidence, and considering certain guidance involved in Tylenol and use during pregnancy. And I think what's a really good example of sometimes the delay that exists absent litigation is the liver toxicity issues with Tylenol, which I think are just now common sense and commonplace. It's common knowledge. But for the better part of, I would say, 4 or 5 decades, the hepatotoxicity issues with Tylenol were not well known. It might surprise you to know that it wasn't until I think 2011, it was after 2010, I think it was 2011 specifically, where the liver warnings were finally put on to the Tylenol labels. And that came after about 4, almost 5 decades of increasing data and awareness that this was an issue. In fact, if you go back and kind of look through the regulatory document, just the regulatory history of this drug, you'll see that there were proposals submitted to the FDA to amend the warnings on the label to reflect the liver issues, but those were essentially ignored all the way until 2011. I think the first one was proposed in the early 90s, and then again there was a follow-up proposal in the early 2000s. But again and again, we see that the FDA, kind of absent, or in this specific instance, absent, sort of a compelling extrinsic force. I think it really failed here. It's a lesson, a lesson learned that it took 4 decades for the liver warning to populate the Tylenol and acetaminophen label, the monograph essentially, when there were scientists as early as 1960 building entire research labs and their entire research careers on the hepatotoxicity of this drug. And Depakote is a more recent example. So this is a drug, it's a first-line drug, valproic acid, used to treat certain mental health conditions. But Depakote actually has a very similar mechanism of action in terms of its toxicity to Tylenol. And it's now been shown that Depakote in utero exposure does cause childhood autism and ADHD. But in terms of like the gap of time it took for like the initial research between the seminal study and the final guidance promulgated by the American Academy of Neurology, it was about 15 years time between the initial seminal literature populating journals and when we saw final guidance from an academic society kind of articulating that connection. And so I think that just gives you a flavor of, the fact that the Tylenol litigation, it really is an emergent public health issue. As I said earlier, reasonable scientists can disagree. There's data out there. There's also conflicting data out there to some degree, and depending on what cohort or type of study you're looking at. Um, but that's to say that we're kind of in the incipient stages of, or this is an emergent public health issue, as opposed to something that's a little bit further developed, like with the liver toxicity warnings. For Tylenol is also the in utero exposure issues with Depakote that took much longer for that literature and for that data to develop. I think we're pretty much out of time, so I'll end there. Do we have? I guess if there are any questions, we can address.
There was another question in the chat by Dr. Mercedes Harris, if you wanted to answer that one.
Yeah, great. So yeah, thank you, Dr. Harris. Let's see. Your question is, have you seen much success with outcomes from the National Childhood Vaccine Injury Act of 1986, or are there many barriers for a successful outcome on a patient's end? Thank you. Thank you, Dr. Harris, for your question. So I think that litigation I use the word litigation loosely because it's more of an administrative process that sometimes these statutes implement. I believe that's the litigation that is currently being resolved or adjudicated in the federal circuit, which is in DC. But I personally have not. It's not something. It was a little bit before my time in the mass tort space. But what I do know is that in that litigation, it was one of the first where case law was developed on that lower civil evidentiary standard I mentioned. So, on equipoise, where most of the time in tort law, we're focused on preponderance, where we have to show, for example, in expert work that an expert has greater than 50% scientific or medical certainty that this connection exists that they're opining on. But with the vaccine litigation, that was attenuated by statute down to just equipoise, as likely as not. And so I think that to me is a huge difference because it's really a case of first impression in terms of how that is interpreted given the state of the science. Does that mean that we don't need to show that studies where that are not statistically significant at 95%, for example, at a 95% confidence level, for example, are admissible. Typically in the jurisprudence, certain circuits have set hard and fast requirements, like the Fourth Circuit, for example. They have a requirement generally when preponderance is the standard, that any study that falls that's not statistically significant at a 95% confidence level is inadmissible. But at the same time, you have the Camp Lejeune litigation going on in that circuit, where for the first time now, the judges are being asked to interpret epidemiology from a lower legal evidentiary standard of just equipoise and not preponderance. So does that mean that that precedent that was set at 95% is now lower? And how much lower is 90%? Is a 90% confidence level sufficient? Is an 85% confidence level sufficient? Those are the answer is I don't know, and the courts haven't adjudicated yet that issue yet. But I think that's from a policy perspective, that's something that there needs to be greater discussion and collaboration between the public health community, the epidemiological community, and the legal community. Because whatever precedent gets set is going to essentially carry forward, right? And it's going to be binding in that jurisdiction and at least persuasive in other jurisdictions. So I think I know of to answer your question a little bit more directly. I know of lawyers who have been successful in getting their patients compensated and for their medical expenses and other forms of damages and that litigation. I personally don't have experience, but I think that's a great question because it opens up that broader policy discussion we were having earlier.
All right, awesome. So let's go ahead and give a collective round of applause to Dr. William Lee. I think this has been an excellent conversation. You've taken us all the way from differentiating, the Venn diagram between mass tort as well as class action lawsuits, differentiating like general causation from specific causation, PMKs and PMQs, which I've not heard of before. And then I love the expert work as an exercise in advocacy, and then all of these different litigation examples, past and present. So thank you so much. BCPH is happy to have you, William, as one of the health innovators to watch the cohort 2024. So definitely people go ahead and connect with William that way, or go to bcph.org and look up more information about him there. Final words, William.
No, yeah. Well, again, thank you, Dr. Carpenter, for the opportunity, and thank you everyone for your attention and for your questions. It was, it was great to be able to share some of the work that my team and I do with folks on the call.
Excellent, awesome. And stay tuned. We'll continue to have lots of webinars throughout the fall of 2024 with experts such as Dr. Lee, and then experts that you actually heard from last week, Dr. Mercedes Harris. Thank you guys so much.
Thank you, everyone. Bye.
All right. So thank you. So did you have any updates to the slides or the ones that you sent us? Is that okay if we make that available to people who request them?
Yeah, I just noticed that we have a lot of questions in the Q&A that we didn't get to. I think maybe I can take another peek at my slides, and then I'll PDF the final version for you to circulate, Dr. Carpenter.
Okay.
But I think I'll also maybe just answer. Since we didn't get to these questions, I'll in a Word document or something. I'll just answer them, and so you can circulate that as well.
Awesome, excellent. And then so we live streamed on YouTube, so that will be available on the BCPH Studio YouTube probably within less than an hour. So if you wanted to be able to have some of your other colleagues watch that will be there.
Oh, okay, great. Great. And I'm just, before we hop off, I just want to make sure I had Maynard's
Email address.
email address. Yeah. So I got all the questions, I think, and then.
Yeah, that was maynard.clark@gmail.com.